Good morning. The Judiciary Committee will come to order, and without objection, the chair is authorized to declare recesses of the committee at any time. We welcome everyone to this morning's hearing on oversight hearing with Deputy Attorney General Rod Rosenstein. And I'll begin by recognizing myself for an opening statement. Thank you, Attorney General Rosenstein, for appearing for the first time in front of this committee. There is much to discuss today, and we look forward to your testimony and answers to your questions. As chairman of the committee with primary oversight of the Department of Justice and the FBI, I have always supported the department and the FBI in performing their valuable missions to keep our nation safe and to hold individuals accountable for criminal conduct. Yet, I and many on this committee now find ourselves in the very difficult position of questioning the actions of both prior and current department and FBI leadership. You have a unique role at the Department of Justice in that you appointed Special Counsel Mueller and have a supervisory role over his investigation. It is therefore very appropriate for you to appear before this committee to answer questions related to the scope of the Special Counsel's investigation, as well as its current efficacy in light of various events calling into question its impartiality. Reports on the political predisposition and potential bias of certain career agents and department lawyers on Special Counsel Mueller's team are deeply troubling to all citizens who expect a system of blind and equal justice. The Department of Justice investigations must not be tainted by individuals imposing their own political prejudices. We are now beginning to better understand the magnitude of this insider bias on Mr. Mueller's team. First, we have FBI agent Peter Strzok and FBI lawyer Lisa Page exchanging communications showing extreme bias against President Trump, a fact that would be bad enough if it weren't for the fact that these two individuals were employed as part of the Mueller Dream Team investigating the very person for whom they were showing disdain. And calling it mere disdain is generous. According to the documents produced last night to this committee, Mr. Strzok and Ms. Page referred to the president as an utter idiot, a loathsome human, and awful, while continually praising Hillary Clinton and the Obamas. These text messages prove what we all suspected. High-ranking FBI officials involved in the Clinton investigation were personally invested in the outcome of the election and clearly let their strong political opinions cloud their professional judgment. And this was only an initial disclosure containing heavy redactions. Second, former embattled FBI General Counsel and current Mueller prosecutor Andrew Weissman expressed his awe of a former DOJ official for shunning the president and failing to faithfully execute the law. However, we are the ones now in awe that someone like Mr. Weissman remains on an investigative team that looks more and more partisan. Third, we have learned that a top Mueller prosecutor, Jeannie Rhee, in addition to the other actions that would normally justify recusal, served as an attorney for the Clinton Foundation. Aren't Department of Justice attorneys advised to avoid even the appearance of impropriety? A former Clinton employee is now investigating President Trump. This seems to be the very definition of appearance of impropriety. Fourth, we have just recently learned that another top Department of Justice official, Bruce Orr, has been reassigned because of his wife and his connections with the infamous dossier and the company from whom the opposition research document originated. We hope to hear your assessment of the foregoing conflicts, whether individuals are being held accountable, and whether you still have confidence in the judgment of the special counsel you named and supervise. Regarding the Clinton email scandal, you, along with Attorney General Sessions, have to date declined to appoint a second special counsel to investigate the improprieties that continue to surface related to the handling of the Clinton email investigation and other events surrounding the 2016 election. These are some of the important issues on which we will focus our energy and questions today. We want to understand your participation and the department's involvement in addressing both investigations. Mr. Deputy Attorney General, the Department of Justice's reputation as an impartial arbiter of justice has been called into question. This taint of politicization should concern all Americans who have pride in the fairness of our nation's justice system. While we continue to call on you to appoint a second special counsel, as you are aware, we have also opened our own joint investigation with the House Oversight and Government Reform Committee to review FBI and the Department of Justice's handling of the Clinton email investigation. I want to thank you and Attorney General Sessions for recently committing to provide us relevant documents to enable robust congressional oversight of this matter. I implore you to continue to work with us on these and other important matters facing our nation. One of these matters involves a critical program for our national security, FISA Section 702. This committee passed, on an overwhelming bipartisan basis, the USA Liberty Act, which maintains the integrity of the program while protecting cherished civil liberties. This overwhelming vote occurred despite the department's lobbying efforts against our bill. The USA Liberty Act was characterized as bad for the program, highly problematic, unworkable, and a proposal that would effectively dismantle Section 702. However, the reality is that this committee's legislation struck a balance that promotes national security and civil liberties. I hope to hear from you why the Department of Justice felt it necessary to oppose a bill that would reauthorize 702 and instill confidence in the American people that their privacy and civil liberties are respected by a government whose duty it is to protect them. The Department of Justice must reacquire the trust of the American people. I know there are thousands of Department of Justice employees and line agents in the department, in the Federal Bureau of Investigation, that are dedicated individuals that are dedicated to upholding the rule of law and protecting the American people. And I hope that we can come to a conclusion about those people who have not met that standard in this hearing today. Thank you, Mr. Deputy Attorney General, for appearing today. I now yield to the gentleman from New York, the ranking member of the committee, Mr. Nadler, for his comments.
Thank you, Mr. Chairman. Before I begin my statement, first, let me wholly endorse the comments of the chairman with reference to Section 702 and to the legislation that we reported out of this committee. And second, I want to acknowledge a letter the chairman and I received last night from the Democratic women of this committee. Our colleagues have written to ask that we convene a hearing regarding the serious and credible allegations of sexual harassment and misconduct leveled against President Trump by at least 19 women. Without objection, I ask that this letter be made part of the record.
Without objection, it will be made a part of the record.
And let me be clear, I unequivocally endorse this letter. We should convene this hearing as soon as possible. This is an opportunity for us to lead and to show the country that this kind of behavior is unacceptable at any level of government. Mr. Chairman, let me start by saying welcome to the House Judiciary Committee, Mr. Rosenstein. For the better part of a year, my colleagues and I have implored this committee to conduct real oversight of the Department of Justice. On January 24th, 2017, we wrote to Chairman Goodlatte insisting that the committee hold hearings on President Trump's conflicts of interest at home and abroad. Citing to experts across the political spectrum, we showed that, quote, the administration's attempts to address its ongoing conflicts of interest are so far wholly inadequate, close quote. 6 weeks later, Attorney General Sessions was forced to recuse himself from the Russia investigation, but we have not held a single hearing on the question of conflicts of interest. On March 8th, we wrote again to the chairman, encouraging him to call hearings on, quote, Russia's alleged interference in the U.S. election. Again, no such hearings were ever held. In fact, this committee, which during the Obama administration held half a dozen hearings around Operation Fast and Furious, received testimony from FBI Director Comey 3 times in 13 months, and detailed staff and resources to a Benghazi investigation that cost the public almost $8 million, this committee, from Inauguration Day until 4 weeks ago, was largely silent in terms of oversight. We haven't lifted a finger on election security. Attorney General Sessions told us on November 14th that he has done nothing to secure the next election from threats from at home and abroad. We have not once discussed the president's abuse of the pardon power. While the hurricane bore down on Houston, President Trump sidelined the Office of the Pardon Attorney to pardon a serial human rights abuser who bragged about running a concentration camp in Arizona. And we have not held a single hearing on allegations of obstruction of justice at the White House, not for lack of evidence, but because, in the chairman's words, quote, there is a special counsel in place examining the issue, unquote, and, quote, several other congressional committees are looking into the matter, and the committee, quote, does not have the time to conduct this critical oversight. I ask my colleagues to keep those excuses in mind. Now, with the year coming to a close, with the leadership of the Department of Justice finally before us, what do my Republican colleagues want to discuss? Hillary Clinton's emails. Let me repeat that. With all of these unresolved issues left on our docket, a week before we adjourn for the calendar year, the majority's highest oversight priority is Hillary Clinton's emails and a few related text messages. As we saw in our recent hearings with the Department of Justice and the FBI, my Republican colleagues seem singularly focused on their call for a second special counsel, and failing that, on the need to investigate the investigators themselves, ourselves. The White House has now joined the call by House Republicans for a new special counsel to investigate the FBI. The President's private lawyers have done the same. I understand the instinct to want to change the subject after the Flynn and Manafort indictments, but this request is grossly misguided for a number of reasons. First, it shows a fundamental misunderstanding of how the special counsel regulations work. Some criminal investigations pose a conflict of interest to the Department of Justice. The Russia investigation is such a case because of the Attorney General's ongoing recusal and because department leadership assisted in the removal of Director Comey, among other reasons. In cases like these, the Attorney General may use a special counsel to manage the investigation outside of the ordinary chain of command. But the key here is the criminal investigation. That's what special counsel does. The department cannot simply assign a special counsel to look at things that bother the White House. There has to be enough evidence to have predicated a criminal investigation in the first place. Then and only then, if the facts warrant, can a special counsel be assigned to the case. So far, there has been no credible factual or legal claim that anybody at the Department of Justice violated any law by deciding not to bring charges against Hillary Clinton or by attempting to meet with Fusion GPS. In other words, there is no investigation to which the department could even assign a new special counsel. Second, the list of grievances raised by the majority for review by a new special counsel also seems wildly off the mark. For example, there is nothing unlawful about Director Comey's sitting down to draft an early statement about the Clinton investigation, nor would it have been unethical to outline his conclusions before the investigation was over if the clear weight of the evidence pointed in one direction. Nor is there anything wrong with FBI agents expressing their private political views via private text message, as Peter Strzok and Lisa Page appear to have done in the 375 text messages we received last night. In fact, department regulations expressly permit that sort of private communication. I've reviewed those text messages, and I'm left with two thoughts. First, Peter Strzok did not say anything about Donald Trump that the majority of Americans weren't also thinking at the same time. And second, in a testament to his integrity and situational awareness, when the Office of the Inspector General made Mr. Mueller aware of these exchanges, he immediately removed Mr. Strzok from his team. To the extent that we are now engaged in oversight of political bias at the FBI, this committee should examine evidence of a coordinated effort by some agents involved in the Clinton investigation to change the course of the campaign in favor of President Trump by leaking sensitive information to the public and by threatening to leak additional information about new emails after the investigation was closed. On Monday, Ranking Member Cummings and I sent a letter to the department asking for additional materials related to these leaks, as well as to the claims that these efforts may have been coordinated with former Mayor Rudy Giuliani, former National Security Advisor Michael Flynn, and other senior figures in the Trump campaign. Third, the President's call for an investigation of the investigation is at best wildly dangerous to our democratic institutions. On the one hand, the President's old lock-her-up cheer seems quaint after a couple of guilty pleas by Trump associates. On the other, as former Attorney General Michael Mukasey, no fan of Hillary Clinton, has said, the President's continued threats to prosecute his political opponents is, quote, something we don't do here. If the President were to carry out his threat, quote, again from Attorney General Mukasey, it would be like a banana republic. Finally, and most important, this investigation into the investigation cannot credibly be a priority for this committee at this time. I understand the instinct to want to give cover to the President. I am fearful that the majority's effort to turn the tables on the special counsel will get louder and more frantic as the walls continue to close in around the President. But this committee has a job to do. President Trump has engaged in a persistent and dangerous effort to discredit both the free press and the Department of Justice. These are the agencies and institutions under our jurisdiction. Every minute that our majority wastes uncovering for President Trump is a minute lost on finding a solution for the Dreamers, or curbing a vicious spike in hate crimes, or preventing dangerous individuals from purchasing firearms, or stopping the president from further damaging the constitutional order. I hope my colleagues will use today's hearing as an opportunity to find their way back to the true work of the House Judiciary Committee. I thank the chairman, and I yield back the balance of my time.